Hi, so in this video I want to go over police powers regarding stop and search, and also police powers for when they detain and when they're questioning a subject, essentially. So these are kind of the topics that I want to cover. So to start, the rules and the powers available to the police when conducting stop and search are laid out in the Police and Criminal Evidence Act, 1984. This is abbreviated to PACE, and it's Code A. So some of the basic rules of stop and search can be laid out as that the police have a right to stop and search any person, any vehicle, or anything in or on a vehicle for stolen articles, blades, or fireworks. They possess a right to detain individuals and vehicles for the purpose of conducting a search. And these conditions are only applicable if the officer believes they have a reasonable ground for suspicion. So, you know, even if there was any of this stuff, if the officer didn't have a reasonable ground to believe that the vehicle possessed those items, then they wouldn't be allowed to search. They must have a reasonable ground of suspicion that a suspecting person is in possession of, or the vehicle contains, prohibited articles such as drugs, offensive weapons, and later amended in the 2003 amendment, articles that invoke intent to cause criminal damage, for example graffiti. During the course of a stop and search, an officer must give their name, station, and the reason for the search, backed up by Osman v. Southwark, Crown Court case in 1999. This was a case in which the officer did not meet the requirement, resulting in the search being classed as unlawful. Subsequently, anyone present on the premises must be given the reason for entry. Some additional rules that are applied to stop and search include the requirement of an appropriate adult to be contacted during the stop and search if the subject does not hold legal capacity. So essentially, if a subject doesn't hold legal capacity, it means that they are either a child or they're not mentally capable of understanding the ramifications of what they're being talked about or what they're being told. So they would need, an appropriate adult who's in their right mind to be able to make sure that the police are appropriately using their powers. So additionally, voluntary searches are not allowed if the legal precursors for a search are not met, even if the individual asks and offers to give a search. And there are some exceptions to the reasonable suspicion precursor, and that's when an officer is acting under the Criminal Justice and Public Order Act of 1994. If they're authorized by a senior officer and reasonably believe serious violence may take place in the locality of his area, an officer does not need reasonable suspicion for a specific vehicle, namely because they have reasonable suspicion for the entire area, essentially. So stop and search powers, they're quite contentious. They have their critiques, and one criticism is that there is an overuse of stop and search powers on ethnic minorities in the UK. This perspective does have weight behind it, with watchdog IOPC calling for the reduction of overuse of this tactic, citing the evidence that black people were 7 times more likely to be stopped and searched, with specific examples of this bias manifesting in cases where a black boy was searched nearly 60 times between the ages of 14 and 16. Some may argue that this is permissible, as statistically black and ethnic minorities are more likely to participate and be affected by crime. Some argue that this justifies disproportionate policing of different demographics, as police have so many resources, only have so many resources, and it's a net benefit if they're used in a way where they will be more likely to stop, prevent, and combat crime. However, while this may be true, the door becomes open to the reinforcement and development of racial-based prejudice influencing suspicion, perpetuating systematic bias against racial minorities. And while even if it is true that people in these groups may be more likely to engage in certain behaviours, it doesn't justify police suspicion being raised by internal characteristics, and then therefore making them more likely to be searched, essentially. So there are rules relating to search and seizure. So generally, police operate under the acquisition of a warrant when they're searching a premises, and when they are acting under this precursor, To gain the powers to search the premises, there must be reasonable grounds to suspect that a serious arrestable offence has been committed. There is material on the property that is significant to the investigation, and that it is not practicable to communicate with the occupier, so communicate while the search is being conducted. Section 17 of PACE lays out police powers to search premises without a warrant, however, and this is under the precursor that it is to arrest any person, save life, limb, or property. So, more specifically, police can enter premises to conduct an arrest or search for an individual who is out for arrest, more specifically someone who is named in an arrest warrant, who has committed an arrestable offence, or who is an escaped prisoner. So, regarding this power, there must be reasonable grounds for suspicion that the person is on the premises. There are limitations on this power in respect of separate dwellings, and the search can only be executed to the degree necessary for the stated reason for the search. Additionally, police must inform residents of this reason for the search in accordance with the precedent demonstrated in McLaughlin versus the Chief Constable of Essex. In special circumstances, police can enter without stating the reason, if doing so would be impossible or impractical. Additionally, if police believe they could prevent a breach of the peace, they can enter a residence without permission. This also extends to private properties. If the occupier has granted consent, then police may conduct a search. However, this must be in a written format, and if the occupier is inclined to retract their consent, police are obligated to stop the search and leave the premises. So when any of these conditions are breached, the search is then classed as illegal, and an individual affected by this abuse of power can sue under the tort of trespass. Despite this, evidence obtained in an illegal search may still be used as the basis for a prosecution, with the court having complete discretion over what evidence is admissible. The defense may have illegal evidence excluded, however, if they believe it would have an adverse effect on the fairness of the trial. So, next I want to talk about the procedure following the arrest and during the detention of a suspect. So, once someone has been arrested, the broad outline for the procedure following the arrest kind of goes as follows. So when someone is arrested, they're brought to a cell and they can be questioned on whether they can be questioned, and after that they can either be released or charged with the crime. If there is not reasonable evidence to charge them, the police must let the arrested individual leave after a certain amount of time. On a more micro-specific level, following the arrest, the police officers are required to inform the suspect that they are under arrest, even if it's obvious. So there's no set word format, they can phrase it however they want. Following this, they are allowed to search the individual for any item that could help them escape. However, if it's in a public place, the offender can only be required to remove his outer coat, jacket and gloves to avoid a breach of personal rights and expose the public. Once an individual is brought to a police station, they have several rights that must be respected. According to gov.uk, a custody officer must explain that you have the right to get free legal advice, tell someone where you are, have medical help if you're feeling ill, see the rules the police must follow, known as codes of practice, see a written notice telling you about your rights, such as regular breaks for food, and to use the toilet, and ask for a notice in your language or an interpreter to explain the notice. These are the rules in place to avoid police exploiting their positions over the arrested individual. The individual's possessions are then taken and kept by a police custody officer while the individual stays in a cell. While they're detained, police also have access to certain rights that they can execute to aid in their investigation. They can, without consent, take pictures of someone being held, take their fingerprints, take DNA samples, such as from their mouth, swab of head hair, root. They can, without consent, take pictures of someone being held, take fingerprints, take a DNA sample such as from a mouth swab or head hair root, and a swab of the skin surface on their hands and arms. There are other actions they may want to take, but they would need consent, such as taking blood or urine samples and dental impressions. However, in relation to drink driving charges, they can take blood and urine samples without consent. And they can then store this information on the police database, which after an individual is released, they can later contact the police to request that information is removed from their database, basically. So the next step in this process is the police questioning. So they question into the individual's involvement of the offence they're being held in relation to. And before this procedure, they must read the caution that you do not have to say anything, but it may harm your defence if you do not mention when questioned something which you later rely on in court. Anything you say may be given in evidence, and this is according to the same gov.uk website that I used earlier. If the individual requests legal advice or aid, they cannot question you without this aid present, with some exceptions. And if an individual has the right to free legal advice when the police attempt to question them. If a confession is obtained through questioning the individual, it can be used in evidence to aid the prosecution unless it's dismissed by the court. So the dismissal will occur in circumstances when a confession is obtained by by oppression of the person who made it, or B, in consequence of anything said or done which was likely in the circumstances existing at the time to render unreliable any confession which might be made by him in consequence thereof. And this is according to legislation.gov. So this essentially means that if there was any circumstances that would kind of make the confession seem unreliable, then it could be dismissed. So, for example, by oppression of the person who made it, So by oppression of a person who made it could kind of explain circumstances in which conditions would be met. So circumstances in which such conditions will be met could include police questioning the individual when they have already requested legal advice, when they have not followed procedure and informed the individual of their rights. Oppression of the individual can also include threats, torture, or degrading treatment. So the police can hold someone up to 24 hours before they must either charge you or release you, and it can be applied to change this to 36 hours if the nature of the crime is serious enough, such as murder. The Terrorism Act permits someone to be held for up to 14 days if someone is arrested under it, which is the exception mentioned earlier. And they can release someone on police bail if there's not enough evidence to charge with the crime that they are suspected of. However, they'll have to return if they commit another offence, they fail to turn up at court, intimidate witnesses, or obstruct the court of justice. So when a child or vulnerable adult is being put through this procedure, according to the NAAP, which is the National Appropriate Adult Network, police are legally required to secure an appropriate adult as a procedural safeguard to ensure the vulnerable individual or child are not being exploited. They cannot legally execute a number of their powers until an appropriate adult is present. Since children and certain individuals may be at a mental disadvantage, they could be more likely to have evidence obtained from them unfairly that could lead to unfair executions of justice. The role of an appropriate adult is to prevent this from happening through guidance and a partial role in the decision-making process. So that's essentially going over all the powers that I want to cover. I hope this has kind of been informative and you've learned a few things about police powers, what they can and what they can't do, and what your own rights are. If you enjoyed, maybe like the video and subscribe. Thanks a lot for watching, and yeah, I'll see you later.